What we're finding practically in the application of this case is an attempt by HOAs to distinguish factually the case here, which was a very small HOA with only 4 members and 5 lots, from what is more common in Arizona, which is much larger associations and many, many more owners. So Arizona passed ARS section 9-500.39. For communities, they sort of saw this as a short-term rental free-for-all. Under this particular statute, a city or town is not, it may not prohibit vacation rentals or short-term rentals, except, and there were a number of exceptions there, no need to get into them for the purposes of our talk, but this particular statute and those that came after it was a catalyst of a lot of the amendments that occurred within communities. Now, this particular statute was only a limitation on municipalities. Towns and cities, I think many communities relied on the municipalities to limit certain usage like rentals. And so when that was taken from them, was laid at the feet of individual communities to pass these restrictions, which is why that occurred. It was then amended in 2022, which was the subject of my talk late last year. But essentially, Arizona sort of felt like it may have gone a little bit too far, so it clawed back some of its regulatory authority by giving municipalities some additional control over short-term rentals. Because of some of these statutes, HOAs have now attempted to curb these STRs by amending their various governing documents. And so they did it by amending their bylaws, because that is, generally speaking, one of the easiest things a board can do. In many cases, a board can amend a bylaw by simply a majority vote of the members of the board. Arizona limited their ability to do that by passing ARS 33-1806.01. So that actually had the effect, when it was passed, of saying, okay, if you're going to try to limit rental restrictions, you don't get just to do it in these documents that can be readily changed without any sort of input from the community at large. You actually have to incorporate rental changes in the actual declaration. Understand that basically what Arizona came in to do is, with this statute, is make it so that if a community wants to limit rentals in some way, it has to do so through the declaration, which often takes a vote of the actual membership to pass. All of these statutes over the last 10 years, as they were passed, resulted in an explosion of CCNR amendments, because you are, in many cases, changing uses that people within the community relied upon and expected to be able to do from the time that they purchased the property in that community. And so there's going to be some pushback on that. So now we're going to fast forward 12 years, 2022, specifically March of 2022, and we are met with the case that we're here to discuss today, and that is Martin Callway versus Calabria Ranch HOA. So this case dealt with an HOA, but the HOA was a small HOA. It was only 5 lots, and of those 5 lots, there were only 4 separate owners. And the purpose of the CCNRs was, as stated, to protect the value, desirability, attractiveness, and natural character of the property. The CCNRs stated that they could be amended by majority vote. And in 2018, the owners did, in fact, take a majority vote and added substantial new restrictions within the CCNRs. At the Court of Appeals, Martin Callway argued that all of these amendments, all of these changes and additional restrictions to the land, which affected him disproportionately, required unanimous consent of the landowners. They disagreed with him, saying that the language of the existing CCNRs provided notice to him that the CCNRs may have been amended by majority vote, and that the general purpose statement was sufficient notice of the amendments. From that ruling, Callaway then appealed to the Arizona Supreme Court. The Arizona Supreme Court took the case because it raises issues of statewide importance regarding the scope of an HOA's authority to amend CCNRs. The first thing that the Supreme Court of Arizona found was that a general amendment power provision in CCNRs may be used to amend only those restrictions for which the HOA's original declaration has provided sufficient notice. The second rule that the Supreme Court entered in this case was to determine whether the original declaration gave sufficient notice of a future amendment. We must look to the original declaration itself. It must give notice that a restrictive or affirmative covenant exists and that the covenant can be amended to refine it, correct an error, fill a gap, or change it in a particular way. If it didn't exist before in the CCNRs, it doesn't get to now exist. And what we're finding is HOAs are arguing that, well, that rule makes no sense, right? If a restriction didn't exist or should have existed or they intended it to exist, it would have already existed. We see that HOAs are essentially trying to dissuade courts from really even taking a look at this, or they're trying to shoehorn in this language that the court uses here saying to fill a gap. Rule number 3. If an amendment is invalid, the court will blue pencil the amended CCNRs, striking severable provisions. And so here we find our remedy for the litigation that is to arise from this case. Those who seek to challenge amendments to the CCNRs will actually be permitted to have those restrictions that are invalid just straight up blue penciled, erased from existence effectively. And so that's our notice and foreseeability under the original CCNRs is everything. A reasonable person in reading the CCNRs should be able to foresee what restrictions may be coming down the pike. And so the court goes further and actually says, in determining the reasonableness and foreseeability, Dreamland continues to be good law. So they specifically incorporate the analysis of the Dreamland case on this particular issue. We hold that an HOA cannot create new affirmative obligations where the original declaration did not provide notice to the homeowners that they might be subject to such obligations. They go on to say the notice requirement relies on a homeowner's reasonable expectations based on the declaration in effect at the time of purchase. The law will not be subject to a minority of landowners, will not subject a minority of landowners to unlimited and unexpected restrictions on the use of their land merely because the covenant agreement permitted a majority to make changes to existing covenants. And this is what happened in Callaway is you basically had, of the 4 landowners, 3 of them decided, look, we're just going to do what we want to do and impose that will on the 4th. All right, so let me talk about the inquiry that a court is supposed to take. So the court must apply an objective inquiry to determine whether a restriction gave notice of the amendments at issue. The CCNRs must give notice that a restrictive covenant exists and that the covenant can be amended to refine it, correct an error, fill a gap, or change it in a particular way. Again, going back to this rule that you cannot create a new restriction out of whole cloth, can you see that this restrictive covenant actually exists independent of the amendment? And that this amendment is simply refining that existing restriction, correcting an error in that restriction, filling a gap in that restriction, or changing that restriction in a particular way. That is the analysis that the court is required to do.